Good evening, everybody. Welcome to the Pepe Auditorium and to the third of the annual Susman Conversations on the Constitution and the Courts. My name is Meryl Chertoff, and I direct the Justice and Society program at the Aspen Institute. This is the first day of what is the 40th session of Justice and Society seminars here, and I am delighted to welcome all of you here on this, our first day of the seminar, and share with you some of the excitement that has been going on in our classroom today. I want to make a few acknowledgments here. First, I want to thank the moderators of the Justice and Society seminar who are here with us this evening. They give of their time generously. They come out here for a week at Aspen. And I want to thank Charles Ogletree, who is one of our speakers this evening, and Judge Dermot O'Scanlan of the Ninth Circuit Court of Appeals, who's here with us, for their time in making this such a success. I also want to thank Crystal Logan of the Community Programs for everything that she has done to make this a success this evening. 3 years ago, Ellen Susman very generously agreed to do something here at the Aspen Institute in honor of her husband, Steve. Steve attended the Justice and Society seminar here a number of years ago, and I think found it very meaningful. And they are both dedicated to the notion of rule of law, the importance of the Constitution, and when Ellen and I talked about it, and when she talked about it with the leadership of the Aspen Institute, it was decided that nothing would be more fitting as a tribute to Steve than something that would give the larger Aspen community represented here this evening an opportunity to share some of the excitement that we experience in the classroom. And so I want to thank Ellen so much for all of that. I also want to thank Steve, because Steve, along with Walter Isaacson, hit on the idea of the Justice Circle. And the Justice Circle is a new program which enables friends of the Justice and Society program to get engaged more deeply with our work on an ongoing basis. There's special programming for our Justice Circle members, but also the Justice Circle has done something very special for the Justice and Society program, and that it has allowed us, through the additional funding it has provided, to return to the roots of what the Justice and Society program has always been about, which is human rights, humanitarian law, and the rule of law around the world. And so we are very grateful to Steve and his co-chair, Tristan Duncan, who's also with us in the audience this evening, for that support, and to the members of the Justice Circle, some of whom I see here this evening. So thank you for all of that. Finally, I want to thank Mike Green, who is our wonderful associate director, without whom I probably wouldn't have my right arm, because he is my right arm. And in the audience, we have the members of this year's class of the Justice and Society Summer Seminar, and I want you to know that in our first session today, I told them all that there are invisible threads that connected them when we selected them. We saw some of them, but they are building their own threads, and those threads will be visible, and we think we'll connect them to one another and connect them to the deep ideas that mark what we're trying to do in the Justice and Society Seminar, exploring timeless issues of justice, fairness, and equity. And so I want to thank the young scholars, judges, non-lawyers. We have someone as far away from Kenya, one of the judges of the Court of Kenya, for being here with us this evening. So thanks very much to my class. So without further delay, I'm going to turn it over to Steve Susman, who's going to share a few thoughts for this evening's conversation. Thanks, Steve.
Meryl, there are a lot of... Meryl. I don't want to be accused if it goes off. And I want to thank Meryl for the incredible job she has done in running the Justice and Society program and making events like tonight happen. For our first two Susman conversations, we had Justices Kennedy and Breyer, and my wife Ellen did the introductions. Ellen is now serving as Director of Art and Embassies at the State Department, and since the format of tonight's program is a no-holds-barred debate on a highly controversial subject, I thought I should say a word about why I think this subject is so important. When our Constitution was written, our founders were concerned about keeping the federal government small and avoiding anything that resembled the monarchy that they had fought against. Congress was to check the power of the executive, the courts were to check the power of both, and juries were to check the power of all three. But today, Congress and the executive branch hardly resemble anything our founders could have imagined. Congress has been incapable of passing any legislation or confirming presidential appointments, spends most of its time raising money or investigating the executive branch, and is thought to be doing a good job by less than 10% of Americans. The executive branch consists of hundreds of departments and agencies that run our country on a day-to-day basis, and that Congress created and very clearly entrusted to make policy. Yet members of Congress are now claiming the president is exceeding his constitutional authority by trying to do some things around the edges with immigration, minimum wages, marriage equality, climate change, and filling the vacancies of government positions that make our country run. So the question before us this afternoon is whether the constitutional claims of abuse of executive power are exaggerated, and whether we really should be concerned about whoever sits in the White House running roughshod over the separation of powers doctrine. With a highly respected former Supreme Court justice calling for 6 constitutional amendments to deal with, among other things, the problems of campaign finance, gun control, and redistricting, it is no longer heresy to suggest that our Constitution may need revision. To debate the separation of powers issue, we are honored to have on the left Harvard Law professor Charles Ogletree, who taught President Obama everything he knows about constitutional law. On the right, we have Miguel Estrada, one of the nation's foremost Supreme Court advocates who argued and in part won, in part lost, the recent split decision that Obama exceeded his authority in making recess appointments to the National Labor Relations Board. Our moderator and hopefully referee of a vigorous debate this afternoon is a New York staff writer and one of the country's foremost journalists and television commentators covering legal matters, Jeffrey Toobin. Gentlemen, let the debate begin.
Thank you, Steve. Thank you, Ellen. Thank you, Merrill. Hello, everyone. Okay, Speaker Boehner says the House of Representatives is going to sue the President of the United States for exceeding his authority. Can the House of Representatives sue the President, Miguel?
It depends on the claim. I think it's... Back up. It would be a very difficult lawsuit to frame because of a number of legal doctrines having to do with the competence of the courts to get involved in fights between the political branches. Mostly, I think, the House is going to overcome a number of cases from the Supreme Court that hold that congressmen and senators do not have what the law calls standing to bring claims in court. They are trying to get around that by having a vote of the House and saying that this is not the usual case in which somebody who lost out in the legislative process is coming in, but is really the institution. But that raises a number of issues under the case law about the extent of whether the institution can claim the type of legal injury that the law actually recognizes. Usually, people who come into court are claiming, you took my money, you took my child, you took my house. That's what the law calls an injury in fact, and that's usually what is needed. Now, the suit that is contemplated is in the nature of you are failing to comply with the Affordable Care Act, popularly known by those who love it as Obamacare. And it's not immediately obvious how the members of the current House of Representatives are injured by the president's failure to comply with the law. And it is also likely that as to at least some of them, there are people who are members of the public who are injured by those things and could sue. And so my view would be that it's a very challenging case for the House to bring, even if they do have a vote. And if I had to bet on a court upholding the standing of the House, I would not give them more than 50-50.
Okay, Tree, what do you think? Can the Speaker sue the President? The House sue the President?
Can you repeat the question? No, I know the question. I'm going to be much shorter than my friend here. My answer is surprising. I would say yes. And they've sued the President over and over again, and I don't think they'll be very successful, particularly Congressman Boehner. I think he's attempting to make an important case, but I think President Obama is not afraid of it. And he's already said that he's suing me for what? For doing my job. And he's doing his job. And I think that that's going to be the debate between him and the Congress for the rest of his term. Let me just say this, also, Jeff, I think it's related. The reality is that the president has already been stung, I think, a little bit by the Supreme Court's recent decision, talking about his executive power, how it's going to be limited. But they left a little opportunity, a little window for him to do what he needs to do. And I think everybody knows that the president has been supporting this idea of executive power because he's been stopped by Republicans for every single thing he wants to do. First term, we heard the senator from Kentucky say, we're going to make him a one-term president. Well, he was wrong. And the president has been doing, I think, an important job. I wish he could do better. A lot of things I'd like to say that he hasn't done. But I think that in the next 2.5 years, it's going to be very interesting to see whether he uses executive power for a lot of other things, not just to disagree with the House, but because he has an enormous amount of power and trying to use that is going to be very important.
So are you saying you think that he will have standing, that the House will be found to have standing, they'll just lose on the merits of the case?
I'm not even sure whether the House will lose or win. I think the president will still have executive power. I'm not sure that he's going to be successful with Congressman Boehner. But I do think that people are saying, let's get something done. This is a do-nothing Congress. And I think that people are responding to that saying, somebody needs to do something. How can you not support anything for us in the last 6 years?
Miguel?
Well, I think, there's always a very attractive claim by everybody who wants to do what he thinks is wise to say, oh, the other side is not letting me. It's worth to go back to 1789 and keep in mind that the people that wrote the Constitution actually thought, and they said this, that the government is best that governs the least. And there was some sense for them because in order for laws to be made and change to take place, the assumption of the system was that there has to be consensus as to what we're doing. And what is happening here is less, the political, there's a do-nothing Congress. The executive has been saying that since the 50s or the 60s or the 40s. Everybody says that when Congress doesn't go their way. But what you effectively have is a country that on fundamental questions of policy is divided 50-50. That is reflected in the White House and the Congress. And unless they can come to an agreement as to how to meet in the middle, and they both keep insisting to have 99.44 and 100% of their way, nothing is going to get done. But that's inherent in the system. That's as intended. You can't have change unless you come to an agreement. And the minority in the system was intended to have the ability to slow things down until there is consensus.
Let me talk about a specific first, because as this planned lawsuit is being discussed, it obviously hasn't been filed yet, is the core claim is going to be, apparently, that the Affordable Care Act says that the employer mandate takes place, is supposed to kick in at a certain date, and this administration delayed the date. And there's we all know how the Republicans feel about Obamacare, and their claim essentially is, the food in this restaurant is terrible, and the portions are too small. So Do they have a point that the law says there's this date, the president changed it unilaterally? How can he do that?
Go ahead.
Look, I mean, I had, the flip side of the reaction that Professor Ogletree said. I think it's very difficult for the House to get standing, but if they manage to get standing on this ACA claims, they most likely would win if a court wants to consider them on the merits. To take that example, the statute says this has to come into effect, shall come into effect, January 1st, 2014. Now, the president says, no, I won't do that. That's usually unlawful, and types of things of that nature usually get set aside by the Supreme Court all the time. 2 months ago, the Supreme Court slapped down the EPA, where the statute says you shall regulate if the polluter issues more than, say, 100 tons per annum. Now, the agency said, well, that's unreasonable, we're going to make it much higher. And the court said, no, you can't do that. If Congress says you have to do this on these terms, you don't have any choice to put it to the side. On your point about whether, this is terrible food and we want more of it, the people should be entitled to experience the laws of the country as passed by the representatives, and if that causes untoward effects or people don't like them, this is why we have Congress. Then we can go and say we will change them. But you can't simply say that you pass something in an improvident rush and you're going to fix it on the fly by disregarding what the statute actually says.
What about that?
It's very interesting. We've had debates in Congress as long as we've had Congress. And there have been debates on both sides of the aisle. And it seems to me that as much as we think this is a troubling time, it's no different than all the other issues we've had to deal. We had to deal with the Bill of Rights. We had to deal with the whole idea of what the protection for women. And I think this president's trying to do what others have tried to do, is to move the ball forward and say that I'm going to do some things to make a big difference. And some of the things he's proposed are things that are good for America, even though people are opposing it, I think, because of his politics, because he's Democrats, no question about that. I think that he's going to continue to put the pedal to the metal and trying to make sure that in the next 2.5 years, things are going to change, things are going to happen, they're going to make a big difference. And he's going to wait for the court, if they will, if they're going to overrule what he's doing. And let's think about the Affordable Care Act. This is not new. Every time we've come up again, this has been important. And I remember when President Clinton was running, remember 1993? They call it the Hillary Care Act, right? She was criticized for it.
Whatever happened to her?
She's running for president, and she will be, ironically, the first woman ever elected president of the United States, even though more than 50% of our population is women. It makes no sense at all that's taken so long, right? And I think
I agree with you that wouldn't make any sense.
But I think that there's no question that people are enthusiastic, they're supportive, and I think they're going to be great. My colleague and friend, Senator Elizabeth Warren, is also a great Democrat. She's been very much concerned about middle-class families. She's not going to run against Clinton in 2016, but someday she'll be president. And my secret presidential candidate, who I think will change all this, is someone that is not on the ballot, will not run for office. It's the great, smart, brilliant person that I had the honor of teaching, Michelle Obama. She will be a great president if she's ever decides to run. That's what I hope will happen.
You heard it here first.
You heard it here first,
okay,
exactly right.
But can I just, what about the business of, there's a law that says you have to do this on such and such a date, and they're delaying, and he's delaying the law. Is that okay?
Yes.
Why?
Because he has the power of the executive office to do what needs to be done. He's been doing a lot of things with his executive power, and he's trying to make the Affordable Care Act, people call it Obamacare, I call it Obama Cares with an S, my point of view, because I think it's something that will help the American people. And there are a lot of people who are against it, and I think that makes a good reason. But I think that the reality is that even though people who are poor, people who are rich, they have a lot of problems with this president. The reality is that he's tried to do a lot of stuff internationally, globally, nationally, and locally, and hopefully a lot of that will happen going forward.
Okay, let's talk about recess appointments.
Okay.
I'm sorry,
We do
Miguel,
wanna-
did you want to say something? Go ahead.
Yeah, I mean, look, I mean, I don't mind going to a pep rally for the president, but the fact
Have you been
is,
to any recently?
no, I'm a little bit more
okay.
choosy than that.
No, I thought so.
But the fact is, if there were a private person who were employed by an employer who was excused by the president from providing the mandate, say for example that I work for somebody who but for the postponement would be entitled to coverage, who currently does not have it, that person clearly can sue, and that person can come into court to say, the president has delayed the obligation of my employer to give me a tangible benefit that I want now. That person has standing, and that person has a bang-up claim on the merits. You really can't say, as the answer to everything, the president has executive power. Yes, he does, and one of his executive powers is to take care that the laws be faithfully executed. When Congress says this has to be done on a certain term, and he signs the act, or if he vetoes it and Congress passes it over again, he, no less than any other citizen, has to comply with that.
Miguel, but isn't there a doctrine of law that says, I mean, as the Supreme Court said 2 years ago, surprising many, especially me, that the Affordable Care Act was constitutional as a tax, not as an exercise of the Commerce Clause, that the Internal Revenue Service has the ability, has the constitutional authority or the statutory authority to delay the imposition of taxes in their discretion, and isn't the delay in the Obamacare employer mandate just an exercise of that?
Two answers. No on the first general point. The power to tax is with the House of Representatives. That's what Article 1 of the Constitution says. There is a statute that gives some leeway in the administration of the tax laws to the Treasury Department, and the administration has invoked it here. And whether or not that statute covers the situation is an interesting issue. What the statute actually says is that the Treasury has the power to issue needful regulations for the enforcement of the Affordable Care Act. Now, the question is whether this is really needed, if it's basically a disagreement with the date that Congress picked, or whether this is actually the enforcement of the act. And I would think neither of those things is really true.
Okay. Let's talk about recess appointments. This is a sort of a wonderful relic of a different time in American life. That the recess appointment, I think we can all agree, came in the Constitution when, in the horse and buggy era, Congress was out of session. They couldn't come back with any,
They were gone for 8 months at a time.
They were gone for many months at a time, and the president had to do certain things, including fill vacancies, and so Congress gave him this power. Why, Tree? Why would a president be using a recess appointment now?
Because the resistance from Republicans to anything that he's trying to do, because it's something that the people of the country really want. The majority of the people really want some affordable care in one sense or another. And because even the polls of people watch Jimmy Kimmel every now and then, right? I watch him, and also I watch Fox News. I get a lot of information from Fox News. I really do, right? It's very helpful. And the thing about it, he did this survey, sort of informal survey, how many people would like the Affordable Care Act? Everybody was against it. How many people, Affordable Care Act, people were for it. How many people like Obamacare? No way, we don't want that, right? And I think that the president did a poor job, in my view, of explaining exactly what the Affordable Care Act is covering, when it's going to be implemented, how much it's costing. I agree on those bases, but it's something that we've been trying to get for this country for a very long time. It's a very costly thing, it's a very complicated thing, but I think it's a necessary thing to make sure that people can find somewhere to get medical care for their family. They can get a chance for people who are under 26 to make sure they can get covered. I think that is a salute to this person who's trying to do something against a strain of people who are saying, and politically, that you can't do it.
Okay, let's talk about recess appointments for a minute, though. Okay, Miguel argued the case was called Noel Canning, and I got to say, I mean, Miguel and I are law school classmates. We go back a long way. I'm not saying this. This was one of the great arguments I have ever heard by Miguel in the Supreme Court. It was almost as great as his socks. Talk about what was the issue? What was the issue in the case?
Let us back up. The Constitution has, for these purposes, 2 rules for how you go about naming federal officers. The general rule, this is what you do pretty much all of the time. It says you cannot appoint somebody to be an officer of the United States or a judge or any high-ranking government job unless you get the advice and consent of the Senate. Now, that can be difficult. I am here to tell you, since I was once nominated by a president and filibustered 7 times. But that's the system we have. And if you do not get the Senate to agree, you don't have an appointment. Now, the next one, it says, when the Senate is in recess, you can appoint temporarily until the next session of the Congress. And so that is, the exception. It is unusual to say that you get to involve the break glass in case of emergency part of the Constitution when your reason for doing it is not that the Senate actually is away, but that they will not confirm your nominees. Because under the general rule, they're entitled to do that. If you don't get them to agree, you don't have an appointee. That's what the general rule says. And so this may be viewed as obstruction by some. It is what the Constitution says. You got to get the Senate to agree. Now, in this case, the president got really frustrated because he could not keep the NLRB, the National Labor Relations Act, fully staffed. And it is true that many of his appointees were not timely confirmed to that board. That wasn't really the case with the people that he recess appointed, whom he recess appointed about a nanosecond after he nominated them. Those folks had not even had the questionnaires in to the Senate. And at the time, the Senate was coming in for what the Senate called a session every 3 days. And what happened at the session was the senator who was in charge of the chamber that day, who was a member of the president's party, would gavel the Senate into session, and 40 seconds later, they would gavel the Senate out of session. Nothing got done in these sessions, and the president said, you're effectively on recess. You have gone, you're not confirming my nominees, and name people to the NLRB. He was challenged by a canning company, and as Steve said, I represented some people who were also challenging, who happened to be, I forget the exact number, I think 44 randomly selected members of the Senate.
He's joking, it was all the Republicans, yeah.
Yes. We won in the D.C. Circuit on a very broad ground. The D.C. Circuit said that the recess appointments were unlawful because under the original understanding of the Constitution, you could only appoint somebody if the vacancy had arisen in that recess, and the only recess that counted was in between formal sessions of Congress. I had argued a little bit more narrowly. By the way, Steve, I didn't make those arguments. I only made a very narrow argument, which was the Senate was not in recess, which ultimately is what the court, the Supreme Court said. The court was unanimous, 9-0, 9-zip. There was nobody who believed the president had this power. The 2 people he appointed didn't vote for him, who said, this is an unlawful appointment, but did disagree with the D.C. Circuit on the 2 broad roles. They said that it was not necessary that the intra-session recess be kept out of the clause, and it was also not necessary that the last person to occupy the office have left during that same recess. That actually, in many ways, is a huge victory for executive power. It was a loss for this incumbent occupant of the executive branch, but it is a huge victory for executive power.
So if the D.C. Circuit view had prevailed, I think it's safe to say that the recess appointment power, as a practical matter, really would have disappeared, wouldn't you say?
Correct.
So it is not gone that presidents can use it, but they have to use it in narrower circumstances than President Obama used it.
Right. Well, what the court basically said was that the Senate has the keys to this power. They can choose to go, and if they choose to stay by coming in every 3 days and having a 40-second session, that is good enough. And the key sentence in the court's ruling is the Senate gets to decide whether it is in recess. And if they think they are not in recess, then the president does not have this power. This is a question, by the way, that may vary depending on whether the president's party is in control of the Senate. If the Republicans win control of the Senate, he will never have a recess.
Right. Yeah.
Right.
There's no doubt.
If the Democrats keep control of the chamber, as they did during these sessions, they, in theory, could force a recess. This is probably more than you need to know about, the obscure parts of the Constitution that most lawyers haven't ever heard of. But if, the Senate has to come in every 3 days because it cannot be away for more than 3 days without the consent of the House of Representatives. Neither house can go away for more than 3 days without the consent of the others. If the Senate wants to have a recess and the House does not agree, then the Senate can vote for the recess, and the president gets to adjourn houses of Congress under Article 2, Section 3 of the Constitution, which has never happened.
But it can happen. Now, I think what is clear is that a lot of people haven't read the full Constitution and what it says. And the whole idea was the balance of power. We want to make sure the executive have powers. We want to make sure there's legislative power. We want the Supreme Court to decide those issues when there's a conflict. And very few cases actually make their way to the Supreme Court, thank God. And I think that they are trying to figure out what to do based on what is right for the people, what needs to be done, and what does the Constitution authorize. And I think all these little clauses are what any president has to look at and understand it. And that is going to be very clear in terms of what a recess appointment can be. Recess appointments are okay, but the question is what types of recess appointments can you do, and what are the hoops you have to jump through? And I think this president's prepared to jump through them.
Miguel made a reference to something which I think is a big part of this whole story, which is the filibuster.
Right.
There are various ways of counting, but it does seem clear that this filibuster rule in the United States Senate is that you need 60 votes to break a filibuster. There are 55 Democrats now. There were 60 in the first 2 years. Is the filibuster constitutional?
I think it is, and I think that you make bad law when you start saying, well, let me change the number now because it's in some sense damaging to my side of the aisle. That's not a way to decide law. We'll be changing the Constitution every single day, every single month, and the majority can control. We can't do that.
But the filibuster is not in the Constitution.
But it's been practiced over and over again. Like Miguel told you, right? He had to sit 7 times, right?
We can cut to the chase. I think
right.
The filibuster is absolutely constitutional.
Okay.
And necessary.
Article 1, well, I don't know about that.
I think it's necessary for this reason, because it makes clear that the Senate can discuss and debate and agree and disagree, and they can decide who should be appointed and who should not be appointed. It's not just judicial appointments, it's a whole series of appointments.
Article, 1, Section 8 of the Constitution says that each House of Congress shall be the judge of its own procedures. That is the source of constitutional authority for each House to have rules as to how it's going to run the business. They can have quorum rules that are sort of insane. There is a case from the 19th century in the Supreme Court where the quorum rule that actually applied was if there were not enough people in the chamber, the presiding officer could send, the sergeant at arms and do a nose count of anybody who happened to be on the grounds. The Supreme Court said they get to do that. That's a quorum according to the House of Representatives. And that was one of the cases that they cited in saying that even if the Senate is coming in for 40 seconds, if they think that's a session, they get to say that.
Okay, I think it's clear that both of you agree that the filibuster is both constitutional and necessary at some level. Has it been abused by the Republican minority in the current, in President Obama's term? And is that one reason why these fights have arisen? Has there been abuse of the filibuster? Is that why the president has made these recess appointments
I think the answer,
and other actions that are controversial?
the answer to your first question is yes. I mean, it has been abused, no question about that. I don't think you can get rid of it. I think that would make no sense at all. I think that would be contrary to what we believe is a very productive government. And even Senator Harry Reid, who reduced the number for confirmations from 60 to less than that, that was part of the power that he could use as a United States Senator. It's going to be very interesting to see what happens in 2016. Please vote, people. Because I think that's going to have a big determination on what's going to happen in the future of our country, not just for us, but for those who are thinking about running for office locally, nationally. And I think that it's going to make a big difference, particularly to make sure that we count the vote, to make sure that women are given an equal voice.
Miguel, has the filibuster been abused?
Well, I actually take issue with the question. I don't think it makes sense to talk about, the abuse of a procedural rule that is intended to force consensus, right? If you accept that a rule of the Senate says that things cannot happen unless you have 60 votes, the obvious point of the rule is to not have things happen unless you have the consensus of 60 people. And so it's almost anti-commonsensical to say that a rule that is designed to say you may not do something unless you have consensus has been abused when the people who do not agree with the outcome say you don't have consensus. Maybe, it's just basic literacy.
But so you don't think it's been? Do you agree with Miguel? You don't think it's been? You don't think it's been abused? I mean, just because.
Do I think it's been abused? No.
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 Oh, okay. Moving right along then. A related question is whether the president has to defend laws that have been passed by Congress. We have a United States Justice Department, which as a matter of course says, we defend the laws that are on the books. In a highly celebrated case, regarding the Defense of Marriage Act, a law passed with overwhelming support in the House and in the Senate, signed by President Clinton in the mid-90s.
Who was really in his defending marriage stage at the time.
Yes, Miguel. The C-SPAN audience, they're going to love that. That's okay.
He's already served his term.
Yes, but he
criticism a little late.
Is it appropriate for the Justice Department, as it did in this case, to say we are not going to defend the Defense of Marriage Act? We think it's unconstitutional.
The answer is yes, and it's not that this is a snap decision. Eric Holder has been, in my view, a very effective Attorney General, the same way that Robert Kennedy was when he was Attorney General, and others as well, because his point is that I need to enforce the law and I need to get opinions from people who are smart, and he has a whole inherited staff of lawyers, and tell me what I should do. And DOMA was one of those acts that just didn't, make any sense from his point of view, and that's why he got rid of it. And I think that's what we expect an Attorney General to do. I think he's been much more powerful in what he's been doing. He's been talking about the idea that people who have nonviolent crimes or drug offenses should be reduced in their sentences. People who have been given sentences all the way back to slavery should be able to vote. We should not take away the right to vote for people if they've otherwise been paroled and doing well. I think he's trying to use the power that he has in the time that he's Attorney General to do things that Robert Kennedy did and other Attorney Generals did before him, because they're saying the court's not acting, the people are not acting, and these decisions have to be corrected.
You said the job of the Justice Department is to enforce the law. DOMA was the law. How does he get to pick and choose which ones he gets?
What the law should be and what the law is correctly, right?
So he gets to decide what the law should be?
Well, he decided that DOMA was not an appropriate expression of the law. Defense of Marriage Act, right? And think about where we were. I mean, if we were to ask this, not this audience, but ask people 40 years ago, can we have gay marriages? People would have said, are you crazy? No. And can blacks vote 60 years ago? No. I mean, all these things were very much a clear sense about what you could do and what you could not do. And at some point, the Attorney General, who has to enforce the law, has to decide what is correct in the law and what is not correct. And I think that he's been, I think, one of, I don't know how many Attorney Generals that the legislative body held him in contempt, right? Whatever that's supposed to mean, right? But I think that the reality is that he's trying to enforce the law as best he can, given what the circumstances he has to say. And I think he's also understanding that America is changing, a different population than it was 50, 60, 70 years, 100 years ago. It's a very different forum and a very different interest that we have, and he's trying to enforce it.
Miguel, what about that? The Justice Department saying we are not going to defend the Defense of Marriage Act.
Well, let's deal with the general question first. You know, the Constitution in Article 2 sets forth the oath that the president has to take. And the oath that the president has to take is to support and defend the Constitution of the United States. If a president, whether this president or any other president, honestly believes that a law is not constitutional, he has to comply with his oath and not defend that law. There's a federal statute that says that when the president comes to that conclusion, he has to notify Congress so that they can step in and defend the statute. Now, whether that construct works in this specific context is a little bit of it's a little bit of a harder question, and this is why. Most presidents take very seriously the notion that they are, relying on their own independent conclusion as to the constitutionality of a law when they refuse to defend it. And therefore, the Justice Department for decades has taken the view that even if the incumbent executive does not agree with the statute, they will defend it so long as the Justice Department can think of arguments that may be accepted by the court that would support it. One of the famous examples, which probably, well, maybe it's not that famous here, is, the first President Bush did not like, the Cable Act of 1992 when it forced the cable companies to carry networks. It was thought to be a violation of the First Amendment. Ultimately, that law was defended in the Supreme Court of the United States, and the law was upheld 5-4. And so there are many cases in which a president comes to the conclusion that he has doubts as to whether something is constitutional, and he has policy differences with the statute. But even in those cases, the rule has been that you defend it if you can think of arguments that a court would accept because you owe that to the legislative branch. DOMA was a little bit unusual in that it would be difficult to say at the time that the administration could think of no arguments that would be accepted by the Supreme Court that would result in the statute being upheld. It's sort of an irrelevant question now, because whether or not because the administration declined to defend it or because the president was right all along, we don't know. The Supreme Court ultimately held, the statute wasn't constitutional by a vote of 5-4. That could be because the president declined to defend it, or because he was right on the merits. It's difficult to know.
Before we go to questions from the audience, let me just ask you a general question. I mean, not even the subtext, the text of the argument that's going on now is that President Obama has been unusually aggressive in the use of presidential power, whether it's in using his executive power to in effect impose the DREAM Act in terms of immigration, offering waivers from No Child Left Behind, certain matters relating to global warming in the EPA. Has this president been more aggressive in the use of executive power than other recent presidents, or is this merely the spin of his political adversaries?
It's clearly not spin, but I think the reality is that this president has had to face a Congress that would not support things that he thought was of interest to a lot of people, the majority of the people. And so he's used the act more than he should have used. But I think that the president has to do something. You can't be a president that will sit there and nod your head because Congress hasn't done anything. You have to do something. People are needing jobs, they need an education, they need housing, they need public safety, they need all these things. And they need a president to do things that the legislature has decided not to do. And I think he's been very good about doing those things, even though if you were to ask, I would tell you there's some areas where I think he's crossed the line. I would say that about any president.
Which areas do you think he's crossed the line?
I'm not going to tell you in front of this television audience.
Okay.
Miguel? Who's going to reject my pass to come to the White House?
Miguel, do you think, where does Obama stand in the hierarchy of use of presidential power?
Well, I think, the truth is that all presidents try to be very muscular about the use of executive power. This is why talking about issues like executive power in the abstract is best done by extrapolating from the incumbent, which you may or may not like. All of the people that are simply saying today that the incumbent occupant of the White House is just trying to do his job, et cetera, were up in arms when Bush was having the imperial presidency, et cetera. And if you go back in history, FDR had to do land lease, which was not obviously lawful because he could not get around Congress. And so presidents have always tried to expand their executive power. And the question for us as a society is not whether we like the incumbents or that we like, the policies that will flow from it, but whether we would like to preserve the structural protections of the Constitution that says that the executive, whoever he may happen to be, whether you like him or didn't vote for him, really has the power to do certain things. I don't think he is unusual in his assertions of executive power. I think he is as pushy as other presidents have been. He is, if anything, a little bit maladroit about picking legal fights because he seems to pick those that are most likely to get shut down by the courts. If you put off an inflexible deadline on the theory that because I can, that is not likely to fly. If you appoint somebody on a recess appointment, when the Senate is saying, the Senate controlled by his own party is saying, we are in session, that's not likely to fly. And so he is doing what presidents always doing, he's doing it somewhat less adroitly.
Who has a question? Right there in the middle. Now, are we doing microphones here? Yeah. I picked someone right in the middle to make it most difficult. Could you just pass the microphone over there? Oh, who was that? Steve? Steve? Judge? You have a question? No, I didn't think. Oh.
Judge's not going to touch this.
Yeah. All right. Well, anyway, we'll actually this woman I want to reckon. We'll get to this gentleman next. Keep the microphone, but just this woman here first.
One thing you said about the Justice Department and Eric Holder that you felt he'd been effective, and I just wanted to ask Mr. Estrada, in the case of Fast and Furious, and how that was one of the first times that I saw President Obama say that he had heard about it just from watching television. And then I would like to show
what's the question?
The Fast and Furious.
What about it?
I wanted to know why the Justice Department then did not investigate that.
Okay, what's your next question?
The next question was about the Internal Revenue Service and Lois Lerner and the Justice Department investigating that.
Okay, thoughts?
Well, just so that people are all caught up to speed, Fast and Furious is one of those wonderful things that could only happen in the government, where somebody thinks that they can, really make inroads into the drug trafficking by giving guns to the drug traffickers in Mexico. And so this was, hey, government does dumb things all the time, whoever happens to be running the government. This is why the framers of the Constitution wanted very little of this thing. You know, the president came to be aware of this, and there was a question as to whether the Attorney General himself in person had been aware of this. Some in the Congress viewed his answers to that question as not being adequately responsive and as his not having adequately explained himself as to what he knew about these things. And that's why, you know, the House, I believe, held him in contempt. You know, it is, I don't want to single out the Attorney General because, again, when a House of Congress is controlled by the other party, there is always a lot of very close inquisition into the practices of the administration. I personally think this one was so remarkably dumb that it actually did deserve a real investigation. But other people here may disagree. I'll give you Lois Lerner.
The question involved the use of the IRS against political enemies. That's the accusation.
Well, it's always happened, and it's never good. I think it's a very serious problem that all of us as taxpayers face when you're investigated, not because you've done a crime, but just because they have access to your information. I think that's very problematic. In terms of Fast and Furious, I think that was a very problematic decision by Eric Holder as well. I would not have authorized if I were in the Department of Justice, but I understand why he did it, what he thought he was doing. It was a great idea that went bad. It went terribly bad. And I think that makes a big difference. It's almost as bad as the first thing he said the first week when he was Attorney General. I don't know if you remember this, but he said that Americans are cowards when it comes to discussing issues of race. And President Obama then jumped in and said, wait, Eric, don't say anything without getting me to prove it. Eric is older. Eric will nod, say, I agree, Mr. President, but he'll still say what he thinks he's learned and what he thinks needs to be done. So I think that a lot of interesting things have happened, but people focus on the bad things he's done. But I think the Attorney General's done a lot for this country in the last 6 years, and I think that if he stays a little longer, I don't think he's going to stay much longer, but I think that he will go down in history as somebody who pushed the envelope to make sure that justice applied to every single person in America, and not just those who are wealthy, those who are employed, those who are well known, but some of the poorer people in the community as well.
Sir.
Stefan Edlis. Is it on?
Yes.
My question back to the filibuster cloture that you spent considerable time discussing. Unless I'm mistaken, at one time, maybe 50, 60 years, it required 66 votes, and then it dropped down to 60. We know that majority rule is very important. Major laws have been passed by one vote. In your opinion, would it be helpful if the Senate, in its own wisdom, would drop it from, say, 60 to 55, would still have, a majority would still have the power to stop things, and it might speed things up? What is your opinion?
Well, Harry Reid, the majority leader, did drop the cloture rules, the rule from 60 to 50 for lower court judges and for president's executive appointments, and that has led to a lot of confirmations in the past several months, including several to very important courts of appeals. What do you think about that, Miguel? The so-called nuclear option, moving it from 60 to 50?
Well, I think these questions are up to the Senate, right? This is how they think they can do business as a body. I don't think that one is necessarily better than the others. I have never been a senator. I think, as a practical matter, the Senate cannot do business unless it does business on consensus, and trying to force change without the at least help or the acquiescence of the minority is probably a bad idea. But if they can come to a consensus as to what actually works for them, I think that's perfectly fine. That's their job.
What do you think, Drew?
I think it definitely has to be 50 or more. I really get worried about the reduction to below 50, and I get a little worried about the requirement of 60. I think it's going to change when the politics change. When different people are in the Senate, they're going to say, well, we got the votes, and we're going to do what we're going to do. We're going to control the country. I think that's very problematic.
That's what just happened.
In the back.
That's good.
Gentleman back there.
We return to the Affordable Care Act and the ability of the House to sue and whether they'll be successful. Jeffrey, your point that it's a tax. I just want to ask you guys a question about two Supreme Court decisions relating to this. The Supreme Court decided 30-something years ago the administration's ability to write regulations and rules and what the standards are. It's called Chevron. And it basically says unless it directly violates the words of the statute, it is, as long as it's reasonable, that's fine. 2 years ago, the Supreme Court decided a tax case called Mayo Foundation, 9-0, basically giving the administration the ability, the Treasury Department, the IRS, to write whatever rules they want to write, unless it clearly violates the specific words of the statute. The Affordable Care Act has language giving the administration the ability to write rules to properly interpret the provision.
What's your
question?
question?
So the question becomes whether or not, based on the authority given to the administration to write guidance and interpretation, unless it directly violates it, and the right to write regs, there's any way that the House can win that suit.
Well, let
You
me
think
take
yes,
that one.
Miguel?
I think, this actually goes to the merits, if you get back to the past, the standing question. And I think that the answer to that is yes. And I think, the key to understanding why the answer is yes is that I think you have a little bit of advocacy in your description of the Chevron case. What the Chevron case actually says is we do a two-step analysis. We first ask whether the statute actually speaks to this question, whether Congress had an intent, and if the answer is yes, Congress had a particular intent, then the agency has no further role because the agency, just like the courts, have to give effect to the words of Congress. If there's an ambiguity in the statute with respect to the particular question in issue, then the agencies can exercise discretion under Chevron to fill, the gap. And that's what the court calls it, a gap that is, that is there by dint of the ambiguity. Now, it is the stock in trade of federal agencies to claim that there is always ambiguity. Federal agencies will find ambiguity in a no smoking sign. But the fact is that that's not how the courts go about doing it, and I do think that if they go through the Chevron issue on the merits by first examining some of the questions, such as, is this a real date? Is there an ambiguity as to the choice of the date? Then it's unlikely that the administration could win that. It is true, as I said earlier, that there are other parts of the tax laws that give some discretion to the administration with respect to the enforcement of the tax laws. One can fairly quibble whether declining to enforce the tax laws is actually the enforcement of the tax laws.
Secretary Chertoff, also former Judge Chertoff.
Can you hear me? Yeah.
Yeah,
So one of the justifications that you sometimes hear from the administration on some of these controversies, and it's particularly true in the immigration area with the decision to identify a category of people who will not be deported and who the president has indicated will be allowed to stay at least temporarily. One of the arguments that's made is, look, the president gets to have enforcement priorities, so he can decide how he wants to allocate enforcement. So I want to ask you this hypothetical question. Let's assume in 2017 you have a conservative Republican president, and he looks at the economy, he says, boy, this is a really bad economy. We have taxes that are way too high. He goes to Congress. He says, I'd like you to cut the top rate from 39% to 10%. Congress says no. Maybe there's a filibuster, or maybe the House is in Democratic hands. Does the president have the right to use his, quote, enforcement power or discretion to say to IRS, I don't want you to collect anything more than 10% of the amount of money owed by people when they file their tax returns? Would that be a legitimate argument for a president who says, look, I'm trying to save the economy, Congress isn't cooperating, I'm going to use my enforcement discretion?
I would love to have that hypothetical in class, because I think every student in my class, conservative Republican or Democrat liberal, would laugh at it and say, this person has lost his mind. And I think that the reality is that I don't think it will work. I think it has no chance of working.
Well, I just wrote about Ted Cruz at some length in the New Yorker,
Yep.
and he made a very similar point. He's saying, someday there's going to be a Republican president, and what if he says, I think these EPA, the environmental rules that Congress has passed are way too draconian, so I am going to cut unilaterally or increase the amounts of discharges into the rivers that are allowed. So what about that, Miguel? I mean, Mike's example or the EPA
one of the
example?
wonderful things about the hypothetical is that it's only on the surface designed to illustrate something that sounds really silly, but that wolf comes as a wolf. That's actually what the president has done here, because recall that the consequence of not complying with the deadline, if the deadline is applicable, is that you have to pay money into the Treasury. And so what he has effectively done is to say that Congress passed a law that says if you don't do such and such in the year 2014, you have to kick money into the Treasury. And he has suspended, the collection of the tax, which is what the court held it was, right? And so it's not that different from this case. It is a slight and only a slight exaggeration of this case.
Couple more questions before we go. How about the gentleman right there with the blue shirt? It's very hard. The lights, it's hard to see. The two of you can. Well, the guy in. All right. Well, anyway.
Whoever has the mic, speak.
I have a question for the constitutional lawyers. Is anyone in constitutional law try to rank presidents on the basis of abuse of power, try to decide whether they're more Democrats or Republicans that abuse executive power, and have correlated with abuse of power with lack of interpersonal skills to get people who disagree with them to want to affect and change law? Has anyone done that kind of research or work in the law profession?
Not to my knowledge.
The answer is yes, it's been done, and a lot of the Republicans a lot of the people who have been criticized for their use of executive power were Republicans. And I thought what they were doing were very important when you think about Abraham Lincoln and people like that way before we were born. But the whole idea is that I have to do this because this is going to be important for our society. And I think that makes a big sense. And I also want to say this, that I've told this, I said 1,000 times, you can't decide a president's significance after he or she, and there's been no she's, but we hope there will be a she soon, until 30, 40 years after they've served. You have to figure out what impact it's going to have on the public. And that's going to be a time before we get to that.
How about the guy in the blue shirt that I failed to recognize the last time? Yeah.
She just failed to give me the microphone. You recognized it. So my question deals with legal reliance. And if I'm a citizen or a business and an administration chooses not to enforce a certain set of laws, and therefore I take actions that are in conflict with the laws on the books, believing that it's not an issue because the administration's not enforcing them, what would be my legal exposure be to a successor administration that chooses to enforce the laws that are on the books retroactively?
Tough question.
It's actually not that tough.
All right, easy question.
There are two flavors to this question. Number one is in the civil context, for example, when you have not paid taxes that you otherwise would have paid because the incumbent administration says you shouldn't, if by the time that the next administration comes in and changes that and they try to get the taxes from you, if they are within the statute of limitations, which is a big if, then you're done. You have to pay the taxes. With respect to any other type of enforcement action, and I'm thinking especially about the criminal prosecution, usually if you have failed to do something in reliance on official advice, that tends to negate the state of mind that is necessary for criminal liability. And so if you were otherwise to be prosecuted in a criminal court for failure to comply with the law, you would likely get an acquittal just on the theory that you lack the state of mind necessary to violate the law because in good faith you actually thought you were not doing it. That usually is not a defense to the payment of money in taxes.
Damn, Miguel, you are a good lawyer. It's impressive. It's like, God, I didn't learn that much law in law school, that's for sure. Somebody over here? Yeah, right here.
Isn't it true that even if Congress were to be able to obtain a judgment against the president, they would nevertheless not be able to enforce it because they would have to go to the executive branch for that enforcement? And then the executive branch would refuse to enforce that, in which case they could get another judgment against him, which he would refuse to enforce. And therefore, ultimately, isn't the only real check against a president who fails to uphold the law the impeachment power? And isn't that the way it's supposed to be?
What about that?
Two answers. I think, it is an excellent question, and it really does highlight in a dramatic way why courts are very reluctant to get into abstract fights in between the branches of government. That is why, in my judgment, it would be challenging. I'm not saying that they can't do it, but it would be very challenging for the Speaker to convince a court that they have standing, because, and this is a point that you will love, in the DOMA case, you had a question of standing because the administration had not defended the statute in the Supreme Court, and the question was whether any number of people from Congress could. And Justice Scalia, joined by Justices Thomas and the Chief Justice, filed a dissent on the question of standing, where he made exactly that point. He said, what if they don't, comply with the judgment? Well, then what would happen is that the houses of Congress would be required to exercise the weapons in their arsenal, give the president money, not confirm his appointees, or maybe even go as high as the impeachment. But that sort of hypothetical tends to illustrate why courts are very reluctant to find that houses of Congress and congressmen have standing, because if the executive does not comply, then the House of Congress had to resort to the weapons that they had all along.
You two, I think, have been somewhat surprising to me in your willingness to consider these lawsuits. And let me just conclude, because I know we're over time here, by raising an issue that Walter Dellinger raised at a congressional hearing yesterday, which is, if you agree that the House of Representatives can sue the President of the United States, can you envision a scenario where the President can sue the House of Representatives?
Well, I mean, you're making reference to the hearings, that happened yesterday, and if you conclude that one house can sue the president, you would have to envision circumstances when the president would then sue in his official capacity to force official action by a House of Congress. Again, I am not trying to prejudge the merits of a lawsuit that has not been filed. I think everybody understands that the president, I think people on my side of the aisle tend to believe that the merits question is very easy because, hey, it's a calendar. January 1st, 2014 doesn't really have a lot of Chevron ambiguity to it. But the fact is, even people who are driven to consider a lawsuit by the obviousness of the violation, I think, fully understand that these cases can be very challenging to bring in court.
What about the issue of the scenario of the president suing Congress?
I think the president can sue. I think it would be unwise. I think it would be very problematic. And we would be in a very terrible state as a country to have the president suing Congress. There's a good reason for it, but it means that we've lost all sense of and justice when it comes to treating people equally. And I think that will be important. I can tell you this, I have no doubt in my mind that if the president decided to sue whoever she or he was, would find great lawyers like you have in this panel.
And speaking of
they were charged, it wouldn't be pro bono, right?
Please. It depends on who the client is.
Oh, okay.
Please join me in thanking Charles Ogletree and Miguel Estrada.